justiție civilă. Acum, în Republica Moldova avem ca oaspeți doamna din Washington, Statele Unite ale Americii. Ea este în cadrul deschis. Da, cum să vedeți? Nu, mai a fost. Am spus pe mine sau. Dar acolo tot este risc. Acolo se pregătesc judecătorii și procurorii. Dacă artificial aveți de aici.
Aproape de fost ca o lăpcă, dacă...
Este tipar. Azot.
Da, azot.
Da, vezi, da? Bună ziua tuturor, mă numesc Andrei Ceac, sunt președinte Institutului de Justiție Civilă. Împreună cu mine este doamna Liz Seaton, ea este directorul executivă adjunct în cadrul organizației Justice and Straight din Washington, Statele Unite ale Americii. Ei se află aici în cadrul unui program de schimb profesional finanțat de Departamentul de Stat a Statelor Unite ale Americii și administrat programul de către Consiliile Americane, organizații din Statele Unite ale Americii, cu reprezentanță în Chișinău. În cadrul vizitei 2 săptămâni pe care am avut aici cu doamna Liz Seaton, în special am avut obiectiv să determinăm care sunt principalele provocări cu care se confruntă justiția din Republica Moldova, să facem un schimb de experiență între specialiștii, profesioniști în acel domeniu din Republica Moldova și doamna Liz Seaton ca specialist din Statele Unite ale Americii. Am avut mai multe întâlniri interesante, utile, productive la Curtea Supremă de Justiție, la Consiliul Suprem al Magistraturii, la Procuratura Generală, la Parlament și alte instituții de stat. Astăzi suntem aici pentru a avea o discuție deschisă pe o temă generală, în cadrul căreia putem să facem cu reprezentanții societății civile, cu alte persoane interesate din domeniul profesiei juridice și nu doar, pe subiectul pe care l-am intitulat Cooperarea dintre societatea civilă și instanțele judecătorești, experiența de soartă. Și doamna Liz Seaton ne va povesti nouă despre experiența dumneei în acest sens, în calitate de director executiv în cadrul organizației Justice and Straight. Instanțele să rămână, să fie independente și imparțiale. Înțeleg că, așa cum am făcut și în anunț, am spus și în anunț, doamna Liz Seaton este vorbitoare de limba engleză, dumneavoastră va vorbi în limba engleză. Înțeleg cei care sunt participanți de la cunosc această limbă și dacă vor fi necesari, putem să intervenim la orice etapă. Dacă sunt câteva întrebări, concretizări, putem să ne oprim ca să traducem. So, Liz Seaton.
Thanks very much for having me here tonight, and thanks very much for coming to our audience. And I know Andre will translate for me if I present in English. And one of the things I want to say is it's a great pleasure for me to be here in Moldova, and I've learned a lot while I've been here.
Da, mie în general spune că îi pare bine că se află aici în Republica Moldova. Este plăcere
I just proceeded then.
Okay.
I know Andre said I work at Justice at Stake in Washington DC, and I've got a little bit of a presentation for you about what we do there, and I'm very interested in what you would like to discuss as well. But let me go through that. I'm the Deputy Executive Director, which means I'm the second in charge, and we're a national organization in the United States that works across our country to protect the courts. We're the only national organization that focuses on this full-time. And we work with a national partnership of more than 50 groups, some of them national and some of them state, to do this work. And we work in various ways to protect our courts so that they can protect people's rights. That's the whole point of our organization. We do this through public education, litigation, and policy reform efforts, which means we try to advance our country's laws. We work in Washington, D.C. Our office is about 7-8 blocks from this, which is our nation's capital. And this is a little bit of video about our work.
America's courts are a jeopardy. They're supposed to be the one safe place where we can get a fair hearing. But politicians and special interests are tampering with our courts, spending millions to elect the judges they like. They even tried to put some judges in jail. And it's happening across the country. After the Iowa Supreme Court unanimously ruled to allow marriage equality, special interests spent millions of dollars to unseat 3 of the judges. They all lost. 2 years later, the Florida legislature tried to split its Supreme Court in 2 so the governor could stack the court with his allies. And then there's South Dakota's Jail for Judges, a ballot initiative to create a special grand jury for judges who make incorrect decisions. The list of attacks goes on and on and on. So fighting back. That's where Justice at Stake comes in. Through education campaigns, coalition building, and community organizing, Justice at Stake and its allies lead efforts to protect our courts in states across the country. By reforming how judges are selected, we're working to keep special interest money and political pressure out of our courts. Let's work together to fight back. Protect our courts so they can protect us. Take the pledge.
I feel we have a Romanian English problem between our projector and our computer.
Yeah. Our project.
Yeah, I fear we have a problem with our translation between the two, but this is a video that we should put online to try to involve more citizens in our work. In our country, we have a big problem with both spending in political campaigns for judges, and we have problems with the politicians trying to make the judges do what they want. And we also have a problem with politicians not appointing judges to our benches and filling in the seats when we need them. Recently, there was a case at our Supreme Court about how to keep our courts in our country fair and impartial. This is the name of the case here, Williams v. Florida Bar. And basically, this case was about whether a judge who is running for election to be elected to the bench can directly ask people for money to run their campaign. And the Supreme Court said, no, it's okay for states to bar people from being able to do that. This is a very important issue in our courts because it affects about 30 of our states. So it's really, for us, a nationwide issue. This is one of the things that we do every 2 years. We produce reports, how all of our courts are working, and analyze how much money is being spent in them, what kind of political attacks we're having problems with, and how laws are advancing that can better protect the courts so they can fulfill their unique role in our democracy. TV ad spending is one of the big problems in our country. I know this isn't the same kind of problem you have here because your judges are appointed in a different way, but how much money is being spent in these campaigns makes a very big difference for us. And because of that, our people that, I know that there's other kinds of problems with money and political influence here, but people in our country are worried that campaign contributions are making influence on court decisions. Our Supreme Court justices, some of them are standing up and saying very much publicly and in legal cases that our courts have to be fair and impartial in order to be able to do our jobs. This is obviously Justice Ruth Bader Ginsburg. the problems that we're having and our efforts to solve them are reaching a level in our public media where some of the biggest politicians of our time, this is John Oliver, he does a show that's both kind of takes topics and then he does deep look at them, not from a legal perspective, but from a kind of a citizen perspective, and does it in a very funny and clever way. So he did a big segment on the problems in our courts this year. This is Justice Sandra Day O'Connor from our Supreme Court, who's our honorary chair. Came to one of our meetings recently, and she's been a big champion in our country for making our courts work better so that they can do their job for people. And this is one
Great experience.
and it's our Supreme Court, and it's which is the highest court in our country. And the other topic I can talk about a little bit is, so one of the things that is important conversation in our country is a conversation that's going on between the courts, judges, and the lawyers in our country. It's extremely robust conversation. It's very active and it happens in a lot of different ways. And should I just talk about that briefly? I think it's very interesting. And one of the things I know from having been here for 2 weeks is you can't know very much about Moldova in 2 weeks, right? This is a very complex country with a complex history and a complex present day. So I feel very humbled to be here, and I will just talk a little bit about how this works in our country and how it can work best in this country and conversation for you all as leaders and citizens, not for me to be having. But I do think it's interesting to look at some of the ways we do that in the United States, because I've been a lawyer for about 20 years, and that whole time, our judges and our lawyers and our civil society and our citizens, it's a very active conversation in our country. And it happens in several very distinct ways. And I think it's interesting maybe to talk about that a little bit. So first, there is a very ongoing conversation, a strong ongoing conversation between our courts and the judges in them and our lawyers about what the law should be. And by this I mean outside of the court. I don't mean in court cases, although we can talk a little bit about that, but literally outside of our courts, there is a very robust conversation, and it happens on multiple different levels. It happens, we have a national bar association called the American Bar Association, where lawyers and judges get together and talk about some of the most important policy issues in our society. It happens at the state bar level too. So in each of our 50 states, there's a state bar, and there's a state bar association, and there's a lot of different committees. You probably have a lot of different committees. There's a lot of different committees. And on those different committees, often there are a combination of judges and attorneys, and depending on the bar association and topic, sometimes other citizens as well who are not attorneys. For example, I've been on a bar committee with several judges, several lawyers. We met every month to discuss this issue and how best to advance this issue in our state, separate completely from any court cases. And then we've seen in our country the need for people to understand the courts better. And so part of what our judges are doing more public speaking. They do public speaking to society, to just social groups, to bar groups. In one of our states, we've had some problems with political attacks on our courts. The chief justice of that court and his colleagues literally started taking court cases, and instead of hearing them in the big courthouse in the main state capitol, they literally went and started holding case hearings in communities so that people could come and see what's happening and understand how the courts work better. So those are just some examples. There's also, a conversation going on in the legal cases themselves, and I know you have interest on it, but so in some of our, in some legal cases, NGOs are representing, people, just individuals in court. We do that especially where, for example, the first job I ever had was working for an NGO as a legal aid lawyer. So we represented poor people who couldn't afford a lawyer in their cases. There's other kind, there's not a complete right to have a lawyer in a civil case. There is in a criminal case in our courts, but there's a big effort to try to help people with some of their most fundamental rights, whether they're too poor to have a lawyer and get some representation. And we also have a kind of conversation going on in very, very large impact cases. In other words, we're trying to create precedent in the law, in our common law system. A lot of the NGOs file amicus briefs in the cases, and I know you've done that here. And some, in our big cases, sometimes there will be dozens of these briefs on either side. And they address a whole wide range of issues. So it can be issues that are important, but not legal issues. So they could be scientific issues or historical issues. They can address topics that are not within the case. That's part of what's important about amicus briefs, and they can bring a range of different perspectives. Yeah.
And here, I believe that for most of Moldova attorneys and lawyers, there may appear a question about what's the difference between a forensic report and an amicus curiae brief. Forensic report. No, one.
Yeah.
Forensic report. Forensic.
Oh, forensic report.
Yeah.
Forensic evidence.
So, for example, with such an institution as amicus curiae.
Right.
Yeah. But we have a similar institution. So it's a possibility to, for the court and for the parties to ask for some experts, called an expert,
Yes.
to conduct expertise,
Right.
kind of forensic report.
Right. Right.
So for us, there's a question: how do you make this distinction between forensic report and amicus curiae brief?
The forensic report and evidence. It goes in evidence at the trial court level.
Yes. Yeah.
Yes.
This is a means of evidence
Yes.
accepted by the court.
Yes. We have, it's not called the same thing, but yes, we have that too. Right. They can call an expert witness, and the expert witness can be asked to write a report. There can be evidentiary reports filed by the state, for example, like a weapons analysis. So there's a lot of different at the trial court level. Typically, amicus briefs are written at our appeals courts levels.
Okay.
And at those levels, they're not addressing the specific facts of the case. Those specific facts of the case, those things have to be litigated by the lawyers who represent the parties, or the parties themselves if they're representing themselves without a lawyer. But at the appeals court level, typically, that's when we would write amicus briefs into the Supreme Court to try to address. So let me just give you some examples. So some of the examples we would see, for example, in one of our big cases that has just been heard by the Supreme Court, which is about whether or not lesbian gay couples can get married in our country. Whether states, the issue is very specific to whether states can have laws that prevent lesbian and gay couples from getting married. That's one of our big issues, And in that case, there are a range of different briefs that are filed. So on the side against allowing lesbian and gays to marry, for example, there were some briefs that address history, saying, in the history of all of these different religions, there's not been a tradition of lesbian and gay people being allowed to get married, and citing church doctrine. On the other side, there were a bunch of briefs, and some of them would say things like, there is social science evidence to show over the last 25 years that children of lesbian and gay couples do very well by all standard measures, socially, educationally, emotionally, and so forth. So it's not addressing the facts of the case, but about broader social issues.
How does the court sees amicus curiae brief as an evidence, or just as a tool of advocating for cause in the court?
I think the answer is it depends. It's not considered evidence in the case, but if the court accepts the brief and they have to reach certain kinds of standards in order for the court to accept them or take it seriously. In those cases, for example, a court could cite something from one of the briefs if there's evidence in it. So, for example, in the latest case that I was showing you about this fair courts issue, William G. Lee versus the Florida Bar, which was about judges soliciting campaign funds, we signed on to an amicus brief that was submitted to the Supreme Court, and in that brief, it cited one of our reports, and that report showed that people don't have confidence in the court and their decisions when too much campaign cash goes in, and that report, because it's based on research and is very well founded and has been replicated several times, was cited in the court's decision. So they can take notice of those. They couldn't use one of those. They couldn't use an amicus brief. It wouldn't be proper for them to use information in an amicus brief to directly contradict a fact in the case. It's for other purposes other than that, if that makes sense. Yeah. And then I guess maybe I'll just say this, the last, kind of important area, I mean, there's a lot to say about this. This is a very interesting topic, and when I went to write an outline, there's more than we can discuss this evening, but the other interesting thing that's happening in our society, and I don't know if it's happened here, and I don't know if we've ever had a chance to talk about it, is our lawyers and NGOs and social science, political science professors are all writing about the things that courts are doing all the time.
Yeah.
They're writing about them in law journals and law reviews. They're writing about them, in the public sphere. They write about them in other kinds of journals for political science and social science. So there's this kind of ongoing. They analyze. I mean, big cases like these cases, the Supreme Court, they are analyzed every which way. They are written about. Probably these big cases will be written about by several hundred people. And there'll be articles published about them. They'll take all different perspectives. They'll take a look at that case compared to a bunch of cases that have come before, a bunch of cases that are coming up. So there's this very robust writing, research and writing and discussion in our society that's happened. This isn't so much, what's happening with general citizens, but within the legal advocacy academic community, there's this whole conversation about our case law and how it develops and what does it mean and where should it go, and when people think judges got it wrong and why, and it's all just very public and available to people. And one of the great things in our country in the last, I would say, since I've become a lawyer, it used to be that you either had to have a big fancy law library or you had to be able to afford a very expensive legal research tool to be able to get at all of our case law. But since I've become a lawyer, and particularly in the last, I would say 5 to 7 years, our case law has been made very much more publicly available. You can get all of our statutes, meaning our codes, online, and you can see, I think, almost all of the cases now. It's amazing how much that's opened up since I was a young lawyer. That's a long time ago, but it was very hard to get your hands on a case. But now the average person could get their hands on a case. And then I guess the last thing I'll say is one interesting issue being fought out in our society right now is just whether or not to allow cameras in the courtroom. So that video cameras, not no means still shots, but video cameras, so that people could witness the proceedings. That has there's some complicating factors around it, right? Because if it's a criminal case, particularly, who the witnesses are and what they're who the witnesses are and what they're testifying to and all of that can be it actually can be very dangerous for people to be seen testifying. So it may be that the trial courts are not the right level for this, but maybe at the appeals court levels, maybe you only see the lawyers. There's other ways to think about this. And a few years ago, I was up in the middle of the night, as I often am, and I was watching television, and on came actually the Supreme Court of Canada was, they were just showing a video of the proceedings. And the proceedings were about a case, it was about one of the Guantanamo detainees, one of the alleged terrorist cases where a Canadian citizen, a young man who at the time he was put in Guantanamo was 15 years old. And the case was about whether or not his due process rights were being met for somebody who was a minor being held basically without a trial. And there was a whole conversation going on between the United States and the Canadian government about this young man and whether or not he had to be given more process than he had been given to date. And one of the things that I found most fascinating was the Canadian representative who stood up there, they had been contacted literally the day before by the United States to try to ensure that some basic things were being done for this young man, so that by the next day when they got to court, they could report that. And I thought, well, how revealing is that? How revealing is it that they're not sure they've met his due process rights, and so they're coming in the day before a Supreme Court case in Canada that they know is going to be televised in order to try to meet this person's the barest due process rights for this young man who, look, I don't know, maybe he was a terrorist, maybe he was not, maybe he's in the wrong place, the wrong time, I don't know. But that seemed to me to be a very, very telling fact about what the U.S. government's responsibility was. My organization doesn't have a clear position on cameras in the courtroom, but watching that proceeding persuaded me that at the very least our Supreme Court proceedings should be open. The most important cases in our country, I think they should be televised. So those are
Actually, speaking about a little bit about the situation here in Moldova.
Yeah.
So we will speak about the procedure in court. The same, so the recording the taking of hearings is prohibited. With some exceptions, so according to our statutes, our legislation, procedural legislation, it's allowed, and only if the judge permits to film at the beginning of the hearing and at the end when the judge gives the verdict. And the same, this situation is the same in first, the second, the Court of Appeal and the Supreme Court. But the hearings before the Constitutional Court, they're filmed and you can watch them. So the idea is that the Constitutional Court in our country, it has this function to competence to hear and determine whether a law or any other statute adopted that is challenged before this court is according to the Constitution. And finally, to decide whether the law corresponds to the Constitution or is not constitutional. And if it's not constitutional, then this law loses so actually, if we comparing this with the situation in the United States, States of America, this function is belongs to the Supreme Court. The Supreme Court, yeah. So this is the situation in our country. And if we speak about the interest of society for the decisions of the Supreme Court or for decision of the court, it is not so high interest. There's a bigger or higher interest of society for the decisions of the European Court of Human Rights. The fact that they are more public, and people also each time are very interested what kind of violation was found by the European Court of Human Rights, who is the public officer, judge, or any agent of the state who is responsible directly for the violation of human rights and civil liberties. So this is the situation of interest of society for the decision of the court.
I should say some of our state court judges are experimenting with cameras in the courtroom, depending on the kind of case. And, so I have actually been able to watch some of the state court trials from across the country, but it's at the discretion of the courts or the individual judge. And our Supreme Court does release the audio transcripts of cases. There used to be some time delay, but in the last case I listened to, they released it within a few hours. And that's terribly helpful if you're a lawyer, I think, who has experience with the court and has been to the court and recognizes everybody's voices. But I think it's hard if you're the average citizen and you can't tell. I think it's very difficult for an average citizen to tell who's speaking. And I don't even think they would necessarily always be able to tell whether it was one of the justices or one of the lawyers. And if it wasn't one of the justices, which of the justices. I mean, I couldn't tell who they all were, but I also was just in court listening to them a few months ago. So, and I know all their names and a lot of the history of how they've ruled in cases. So,
Yeah, well, it's about 2 or 3 years since our courts were provided with special devices for recording, audio recording of the hearing. So now the parties the parties are allowed to ask from the court on the CD or the video recording. But even though the lawyers and their clients, they have the right to use some audio recording, just have to inform the court, look, I'm recording the hearing, and that's all, and they have this right. Yeah, sometimes, when these recordings are used by lawyers, attorneys, as evidence, and they are very useful for us. So, any ideas, anything about what we are talking about? Yeah? Of course, there are some important differences between the judiciary system in the United States and the system here in Moldova. But at least in our country, what we notice right now is that apply them here in Moldova. The idea is that even though the case law is not so it's not obligatory and official, but non-official, the judge have to take into consideration the previous cases. So that's why now, even though the Supreme Court of Justice is about 3 or 4 years since took this seriously, one of its main tasks to unify the legal practice, make because this is the highest court. It have to take care about the legal practice in our country.
ensuring consistency of the decisions.
Ensure that all the courts will respect and will respect one idea of the same practice on similar cases. And some of special instruments and tools were now adopted, and now they are I can say that they are successfully implemented. So this is a clear evidence of the fact that in Moldova, in a country where we are part of the continental system, so in our country, we let's say we try to implement some of the institutions for the common system. Ideas that are very interesting, and so we had with we had a very good and useful discussion with the chairman of the Supreme Court of Justice. So, and discussed about his proposals, to implement here in Moldova the institution of jurors. So, yeah, I think this is a very, it's a real innovation for Moldova, because we had in past in history we had a kind of hybrid, a hybrid of participation of citizens in this process of making justice. Yeah, was the institution of it was called like asset swap. Some just were taken from the society to participate together with the judge at the hearing of a case. So they just participate as the judges, and they have usually one judge appointed, and the two people, just common people, common citizens, civil citizens, they just were selected according to a procedure to participate at the hearing of a case together with the judge. Yeah, and they had the same vote, the same so their vote was the same vote with the vote of the judge. So this, yeah, but now, yeah.
Should I talk a little bit about how our juror system works?
Yeah, I think.
You guys, do you know how our juror system works in the United States? So the way it works is when you register to vote in our country, you get put into the potential juror pool of people who can be called to sit on a group with a group of citizens on a case and make determinations about that case. And as we were discussing the other day with some of the members of the Supreme Council of Magistrates, our jurors decide the facts. They don't just judges rule on the law, jurors decide the facts, but they can decide which facts are true and which facts are not among all of the evidence presented, and then based on the way the facts are determined, then the judge gives them instructions about if this is true, then this is how the case should come out, and with that, they'll come back, for example, in a criminal case and say whether the person is guilty or not based on that, and then the judge reviews that decision and announces it, and it can be appealed, but so everybody knows everybody who's registered to vote could potentially be called as a juror in a case, and I think it's part of what I think the American system gives citizens some. It's not a perfect system, but gives citizens some confidence that citizens are involved in our courts on a certain kind of level, and making determinations about how our justice system works and proceeds.
Yeah. So of course, it's not so easy. I believe that it will not be so easy to just take and implement the same model, because it works in the United States, in other countries, but nobody guarantees that the same system will work here in Moldova. Yeah, but anyway, we live now in society in some time when it's important that the courts. So it's important for the courts to respond to the needs of the society. Yeah. So and I think that so the flexibility, so the idea of flexibility that to implement and to adapt, implement different new institutions here whenever before, and to try to adapt somehow our court system in order to to meet the needs of the society. It's a very good idea, and we as members of civil society, we are interested into not just looking at the public officials how they are doing this, but we are interested into having an active participation in all this process. That is why we thought that, and we invited you here to speak exactly about your experience in working with courts and in working with other public officials which are responsible for organizing this institution, because this is very important for us to find some mechanisms and some instruments which can help us to improve this communication and collaboration with the courts. So in order to help them finally to find the best solutions for all the necessities, for all the needs of our judiciary. Yeah.
Well, and the more the public knows about the courts and understands it and has a voice in it, the better, the more public confidence there will be in the courts.
Yeah, just transparency is a very important thing, and that's why another one of the activities that you are fulfilling very successfully is like having this type of communication with the court and using this instrument of educating before the court for some of the important issues in society. It's like I mean about this instrument of amicus curiae. This is another important thing that I think here in Moldova we have to think about, because it's very useful and helps society to promote in critical moments when the court have to decide on some important social issues. It helps society to promote the idea and to show the court really what is the interest of different groups of people in society. So finally, it helps the court to determine and to understand what how finally the decision will affect society, and of course this helps the court to give finally the best decision, the best solution for the entire society. Okay, dear friends, if there are some questions, you can intervene.
I have a question about the prosecution office. Do they have any investigating keys? Do they have all these evidence in electronic form or only on the paper?
Oh. Okay, I'm going to confess that I've never practiced law in the criminal area, only in the civil area. So I don't know a lot of details about it, but we have both federal prosecutors and state prosecutors, so different levels of prosecutors, and I think there are different levels of resources available to them. But I think today, more often, most courts are going to electronic systems of filing of all kinds, and there's much less paper practice in the United States overall about particular pieces of evidence in prosecution. I don't know the answer to that. But what I do know is you can see there's been a rapid move to electronic filing systems for most kinds of papers, but what you're talking about is a trial court level practice, and I think they still do provide documents if they have to show them, for example, to the jurors and things. But
And the next question,
Yeah.
I wanted to give, do the lawyers have access to all this evidence? Do they have, all this is considered to be as the sorry about the.
What the prosecution has. Yeah, so there's different procedures that apply in our criminal cases and our civil cases, but in both, there's a requirement that documents be exchanged. You have to ask for them, and they have to be exchanged. Prosecutors are required to bring evidence forward that would tend to show that the person is not guilty of the crime they've been accused of. That does not always work perfectly. Sometimes we find out many years later that an important piece of evidence was withheld, but as a legal matter, they're required to provide evidence that would tend to show that the person is not guilty.
Yeah, I believe
Yeah.
because, the principle of contradictoriality, what I call contradictoriality, how I call it. I forget the right translation.
Yeah.
So the idea is, so I think in any democratic country you cannot find guilty or get in prison a person without, or based by basing the sentence on some evidence that were not, made public, or at least make public to get it from the lawyer
Yes.
of the defendant.
Yes.
Inform him about this. I think just
Yes, but your question is, do they have to provide it in advance? Yeah, in advance, yeah.
in advance.
Yeah, and I've been, in the civil cases where I have been more involved, there's a process called discovery where both sides request documents and the other side produces requests and you exchange documents, and then you say, I think there's another document, you had supplied it, so please supply that now. And in really complicated cases involving multiple corporations, this process can go on and on for a very long time, but it's a very important one because each side then sees what the other one has, and it makes for a more complete hearing of the issues. Yeah, those are good questions. Do you have more? No? Very much.
It was a very good presentation, very useful and interesting for us. Okay, thank you.
See him first time. It tells us so.